So this is the very first episode, or episode 1A perhaps, the pilot episode of the Citizen Effect podcast. My name is Keith Whiddon of Whiddon Criminal Defense and one half of Erase My Arrest. And today we are going to interview, of course, the other half of Erase My Arrest, Mr. Devin Jones. Devin, go ahead and make your introduction for us.
Devin Jones. I am the other half owner of Erase My Arrest. It's me and Keith together. And I have a bankruptcy firm, the Orum Young Law. We practice a little bankruptcy law over there. Today we're going to discuss the Citizen Effect.
And for those that don't know, the Citizen Effect, because you came up with this name, so let's tell the audience and the people listening, where did the name come from and what does it mean? Because you, in fact, are the originator of the name.
The Citizen Effect is really where the concept of finding something and then leaving it better than you found it. And I think that's a profound duty on anybody in this world, is we all find this world in a place, and then we need to leave it better than we found it.
Absolutely. And so with that in mind, how about we start with, where did you grow up? How did you grow up? Tell us some of that story about what it was like growing up as a young Devin Jones.
Look, life's been a wild ride, Keith. Me and Keith, we've known each other going on 13 years. Grew up is an odd term. I think we've grown every year and had different lessons. Life as a kid was great. I grew up in West Monroe, Louisiana. I went to West Monroe High School. I was a graduate of there in 2002. I graduated University of Louisiana after 6 years. One of those good 2 years of 2 years of practicing, 4 years of actually pursuing a degree, and graduated there in 2008, and then went on to law school and graduated law school 2011 from Mississippi College. And me and Keith met in Mississippi College, and it's been a fun growing up every year since then.
We definitely have grown up a little bit every year since then, and definitely learned quite a few lessons, most of them the hard way, at least on my part. But this isn't about me, so what are some of the things, because you had a lot of work experience and you met a lot of attorneys that are really, really important people in the Jackson, Mississippi community. So tell me what it was like, or tell our listeners what it was like learning at the feet of someone just like Morgan & Morgan, because, you work for John Morgan's firm in the Jackson office.
It's interesting that all I ever did was work. It was law school. And I found law school in a place. It was 2008. It was filled full of everybody who was weathering the financial crisis at that time. You had all these professionals coming in there. And I remember looking at the job board. You remember the job board we had in the lunchroom?
I do, yes.
And this is during the day when you actually put it on the job board. And the job board was paper. And everything said, hiring a lawyer 1 to 3 years. And I thought, I have a 1-year-old. How do I get 1 year's experience? And at that point, I realized maybe if I worked in law school, I could argue to these firms that I had a year's worth of experience. So that's really where it came about. And I started working my second semester of my first year. When they specifically tell you not to work, sorry, Mississippi College, if you're listening, I worked. But here's the better part, I worked for free. I worked for a guy named Joel Gordon. He just got out of law school 2 years before that, solo practitioner. We were in a building that when you walked in it every day, the glass had been sprayed with gunfire. It was next to the old Sun and Sands Hotel in Jackson, Mississippi. I worked for him. It was a great experience, but he didn't have any money. And come to find out, a bunch of his friends who were lawyers, they were in their second year and they didn't have a lot of money. So they paid for a lot of meals. In Mississippi, you could serve papers if you were over 18. So a lot of times if I got my lunch paid for, I knew afterwards I had to go give somebody some lawsuit papers. But I spent that first summer between my first and second year working for Joel. We ended up just doing these car title cases where people had been sold a car and the dealership didn't have the title. And these lawyers didn't know what to do. It's all over these discussion forums. They had cases. Well, we found out there was a title bond, and a long story short, you could get a $10,000 title bond. And I connected with the woman who was over the title bond department, and she would issue those to us every time I'd call down there and show her that our guy bought a car, and the registration, it wasn't registered in his name because he didn't have the title. So that kind of started it. And throughout I worked for Joel for a little while, ended up writing some briefs for 2 ex-Supreme Court justices. I ended up working for an individual named David McCarty, who's now Judge McCarty. He's a Court of Appeals judge who I just happened to be introduced to a lot of people. And after my second year, I got a call from an individual named Andre Ducote. And he said, "Hey, I know you're looking for a job. I'll hire you." So I went down to this law firm. It was Morgan & Morgan. They were new to Jackson. Nobody had heard of them. There wasn't any signs. In Jackson, Mississippi, we had Richard Swartz and a few others that were big names, Don Evans. And these were your Gordon McKernans, your big guys. These were the
billboard lawyers.
Billboard lawyers, that's right. They were your mutants. They're making 8 figures, 9 figures, just big law firms. Morgan was new on the block. I showed up, ended up getting a paralegal job for a workers' comp division. And when I got there, they had 1,200 files. And I found out they had an office in Florida, and they had over 600 lawyers at that time. And I was just amazed by it, the way the practice worked. I ended up working for them all the way through until January of 2011 when I went to work at the district attorney's office, basically being an appellate brief writer. So I just had this miraculous string of luck as I was growing up. And I found the law school place in a place where people weren't getting jobs. And out of luck, I managed to find kind of the loophole to law school, which was instead of pursuing academia purely, just start working. And that's the same exact advice I've given to anybody else who went to law school. I believe that's the advice I gave to Keith. I told him, I said, the moment you can get employed, get employed. I don't care if it's for free.
Absolutely, and I followed that advice. And I like to tell people there's one piece of advice from you in law school that I did not follow, and that was do not join moot court board. And my, I guess, naive or ignorant ass decided it'd be a good idea to volunteer for moot court board, and I regretted it basically as soon as I signed up for it. So
I think the moot court board, the law review, I think they have a viable function, and I believe they create generally lawyers who tend to go into insurance defense. And from the first time I spoke with you, Keith, that just wasn't the bread that you were cut from.
No.
And so I think that it has a viable product. Those individuals go off to make great careers in insurance defense and in what we call these white shoe firms that do a lot of corporate work, a lot of what we call highbrow work. But being an independent solo practitioner who's going to open his own firm, hang a shingle as we call it, I think the best thing you can do is sit at the feet of people and learn how it really works, the day in and day out. That's the stuff you don't learn in law school. That's the difference between a lawyer who wins and a lawyer who doesn't.
I could not agree more, because there's no doubt that I learned more from being in law offices, again, from my second semester of law school than I ever learned in a law school classroom. But you talked about being in Jackson and working for Morgan & Morgan in Jackson, and then you transitioned to the DA's office, but that DA's office was here in Monroe. So what was that transition like from where you're living in Jackson and you have a small family at the time, and now you're moving back home where you haven't been in 2.5 years?
I came back to Monroe, and the real reality is that I got back to Monroe because I had been doing work for a criminal defense attorney in Monroe. I did a small brief part for a local criminal defense attorney on a much larger, what we called a RICO Act case that was being tried here. And that attorney actually turned over my information to the district attorney's office saying I needed an externship. At that point in my career, I was headed to tax law school. I was moving my family back to Louisiana while I headed off to Washington, D.C. to head to Georgetown, because I had admittance to Georgetown University for tax law. Criminal law was not on the radar, but the internship with a government agency is what I needed. My work contacts through that string of work I'd done in law school provided me with that. And so just out of pure luck, I ended up at the district attorney's office. I ended up working for a district attorney called Jerry Jones, who we all know in this area, but was a much famed and loved district attorney. during the course of the summer while I was studying for the bar exam, he brought me to his office and said, if I didn't go to tax law school, he would teach me how to be a trial attorney. And what I found out was tax lawyers were rare, but even rarer was a trial attorney. And I had the opportunity to learn from Jerry Jones how to try a case in his district attorney's office. And I just decided at that point it was something I was invested in. I enjoyed it. And I told him I'd do it.
What was the appeal of being a trial lawyer, other than the scarcity of it? What was the appeal of being a trial lawyer instead of being a tax lawyer?
The appeal of being a trial lawyer was that much more over tax law. Tax law is a great career, and it's a career that you deal with numbers. It's stable. You know what's going on. However, if you want to push the envelope, if you want to understand how psychology works with jurors, with evidence, the pinnacle of it is trial law, and that's where, nobody remembers who settled a lawsuit. Everybody remembers who won it in a jury trial. Nobody even remembers the Johnny Depp attorneys who lost the London trial, but everybody remembers Camila Vasquez, who was part of the team that won the trial here in the United States. So I wanted to have a legacy where I could affect change through trying cases. It sets the seminal. If you want to push the envelope of what sets the law, the grassroots of that is a trial.
Well, and this may go off the current road that we're on, but it's not only that you set the standard in a trial lawyer sense, or what set the law, but you also did, as you've alluded to, a lot of appellate practice, and even as a practicing lawyer early in your career, you had a Supreme Court case. Is that right?
That is correct. The first bit of legal action I was probably involved in that would be what I call high stakes, meaning that you had a very high profile case for either the facts or the defendant or the issue at stake, was several Supreme Court cases that I got involved in. And they were Louisiana Supreme Court cases. But most notably, I had 3 in one day that went up. One was an appeal involving an individual who had been convicted of drinking and driving and causing serious injuries to somebody, of which he was now trying to get home incarceration. And that went on appeal, and the Supreme Court essentially did not overturn his sentence. Another one was an individual who had been drinking, got in an accident, killed somebody. That crime was vehicular homicide, and it had been notated as a crime of violence. And that was an issue of first impression for the Louisiana Supreme Court, but it was in the face of Leocal, which was the United States Supreme Court, that said DWI was not a crime of violence. Essentially, vehicular homicide is a DWI with a death involved. The Louisiana Supreme Court sided with me in that case and dissented, or caused distance between itself and the Supreme Court case, and said, yes, it is a crime of violence because you're using a deadly weapon, a vehicle, even though there's lesser criminal intent, meaning there was negligence in this place, not actually what we would call specific criminal intent. It was just general criminal intent, more specifically by statute, negligence. And then the third one was a district court case that said that all misdemeanors had to be allocated between every judge in the 4th District. And for the record, misdemeanors come in and they're given to one judge. They're consolidated. They said you had to put them in front of every judge, which was going to cause the criminal justice system to have to expand the dockets. Prosecutors were going to have to shift around. The Indigent Defender Board was going to have to spend more money to put a misdemeanor indigent defender in every felony criminal section. And at that point, they essentially overturned the Court of Appeals decision that put that in place, and sided with our logic in that brief, which successfully saved the IDB, the District Attorney's Office, and the criminal justice system here probably millions of dollars a year, and not having to institute that.
And so for the case that involved the DWI and the death, though, you talked about how that case was was basically flew in the face of a federal case, or not a federal case, but a United States Supreme Court case.
That was Leocal v. Florida. It was the United States Supreme Court case, and the defendants in our case, appealed it to the United States Supreme Court, who of which denied writ, just basically said no. By denying it, they allowed the state court decision to stand. So it put a floor to that crime of violence when a charge involves DWI. I said, yes, if you kill somebody, it can be a crime of violence. And that was a very seminal case as far as rights, as far as sentencing of people who have committed DWI that caused a homicide. Because at that time, if you committed a crime of violence, you were required to serve 85% of your sentence.
Do you think that was one of the most significant appeals cases that you handled, or do you liken it back to the other case regarding disbursement of misdemeanor cases? What do you think was your most important involvement in an appellate case?
Well, I think whoever's discussing it as far as importance, they're probably more important to people for other reasons. To me, the one of notoriety would be the Oliphant case, which is the vehicular homicide case. The case of most significance probably to the criminal justice system would have to be the Danielle Ullman case, which is the one that decided that you didn't have to have more than one judge hear misdemeanors. You could allocate them all to one judge. That one is probably the most significant because it would have caused the legal field across Louisiana to rethink the way it was done, and possibly cost a very strained legal system millions of dollars to redo. And at this time, and still to this day, the COFRs for the criminal justice system are so very limited, especially with indigent defense, that it probably would have needed to be rectified by the Louisiana legislature.
Well, I guess the better question is, which one means more to you? Which one, because you've listed basically your Mount Rushmore, but you can't have a Mount Rushmore. What's the one? What's the one that is the most important for you? Why?
If I had to pick one, I would pick the Oliphant case. It's the most important one to me. I was 6 months into practice when that case came about. There were a lot of naysayers about that case. And there was one judge who supported me. His name was Judge Harmon Drew. He was a Second Circuit Court of Appeals judge. He actually wrote a dissent from denial of rehearing. Has to be the most nebulous writing that exists. He dissented from the denial of a rehearing of an appeal and said that, yes, that my position was correct. And a year later, when the Supreme Court came out, they said, yes, it was correct. That's the most significant one to me. There was a lot of naysaying around that. And I was a young lawyer who was unknown. The defendant is a very well-known person. And the crime that was committed was ferocious and horrendous, I should say. But it doesn't make him a horrendous person. It was a horrendous crime. The act was. He had a long list of things that he had done for the community, and very well supported by his community. Not a bad person, just a bad act. So there were a lot of people who were very upset by the lengthy sentence and the lengthening of the sentence by 85% crime of violence designation. So that one most personally to me was because it was the first time that I faced real negativity. And in the face of negativity, it became positive with the win in the Supreme Court, which changed the landscape of vehicular homicide.
And you talk about that negativity, and obviously you're always going to receive opposition from outside counsel and their clients and even people that are going to be on the defense bar in total. But did you even face adversity or naysayers behind closed doors in your own office?
I was young at that age. I was 28. There were some people who were upset about it. It was an upsetting opinion across the board. Many people felt 25 years was just too much time for a person this was their first crime they had committed. So I believe the naysaying to me in negativity that I experienced about it wasn't personal negativity. It was negativity regarding the outcome of the case. It cut across the board. It was a hotly discussed case. And it's what I learned in early on in practice is that many people will tell you no, and you will receive negativity for your view or for your idea. But if you believe in it, much as I believe this was a crime of violence and this was a correct ruling, go for it. There's not many people who support people. Now, was the negativity done in a way that to cause harm? No, they were just negative about the outcome. So yes, there was negativity across the board over this. Many people expressed that they were upset with the original decision in this case, which was to sentence him to 25 years plus the 85% crime of violence tag.
And now, other than the appeals that you did in Morehouse Parish, you also got to kind of have your own, a lot of freedom up there. So do you think that, what was some of the freedom that you enjoyed being in rural Morehouse Parish and starting your legal career as a prosecutor?
Keith, I'm not from Vernon Parish like you, so it was a new day to me. I know for you it had been an uptick in population.
Definitely an uptick in population.
But coming from Ouachita Parish, having grown up around here, to move to Jackson,
which is bright lights and big city compared to where we come from.
Correct. That was eye opening. But
Absolutely.
to then go back and come to Morehouse Parish, it was probably one of, in hindsight, the best things that happened in my career.
Was it discouraging at first being assigned to this rural parish?
You know, I was never discouraged. One benefit is that your boss only came up there once every Tuesday, unlike where he was in Ouachita Parish 4 days out the week. That was great as a young lawyer because you know you're going to make mistakes, and you just have to not make them on Tuesday. Is a lot better than not having to make them on Monday, Wednesday, Thursday, and Friday. But I believe it to be one of the most critical assets. I was handed a misdemeanor docket. Quickly thereafter, a lawyer who was with us resigned to go to private practices, enjoyed incredible success, but was an incredible lawyer. To have to fill his shoes to a degree for a little while, and with a felony docket, I just had freedom to make mistakes. And so it's probably the best learning was as I was 28 years old and I had the freedom to make mistakes as long as they weren't on Tuesday without penalty for the most part. And so I believe a lot of my creative freedom in law stems from the just vast majority of trust that was given to me by given that position to try misdemeanors, felonies, traffic tickets, protective orders. I stood in juvenile court, child support court a few times. I believe that that's the point where I realized that you're probably going to fail more than you succeed, but eventually you'll catch your stride, you'll figure it out, and you'll get the confidence with it, and from there you can just build. I think many people are held back by the concept that they're going to fail. You will fail. That's just life. But if you have to know that you can do it again, just pick it up and do it again. Nobody remembers how you fall. They remember how you get up. And so nobody remembers a lot of the failures I had up there. The only time they really remember it was on Tuesday when my boss was there and he would tell everybody about it. But for the most part, the successes are what's remembered.
Yeah. And so what do you think was one of your biggest failures in being a young trial lawyer or young prosecutor in a rural parish?
My biggest failure, probably as a prosecutor in that parish, was as a young prosecutor. I remember one time I had a dope trial. Now, this is probably the worst story I can tell, and I've told it before, and Keith's smiling because he's heard it. And I had never taken evidence class. This is true. I was learning how to try cases by reading appellate records and reading great lawyers and great defense attorneys, some of the greatest defense attorneys we have here in town.
And also some very bad examples are written into appeals records as well.
You know, I just had the benefit of reading great stuff. I don't remember reading anything bad. I remember reading homicide cases. In any case, what I didn't read in there was how to admit a bag of marijuana into evidence. So I called a case up and decided I'm going to try this marijuana case. He threw the marijuana on the ground. Officer walks up, sees it right next to his shoe. If you're an unseasoned person, you say that is an easy case.
And mind you, this is a judge-only trial because it's a misdemeanor. Is that right?
That is correct.
So you didn't have an audience of jurors who were...
And I picked a judge who I'd known since I was a kid so I could impress him with my skills.
How did that go?
I'm sure he was impressed, but probably not with my skills. At that point, I'd only been practicing about 3 months. I called the case up. I get the officer on the stand. I asked him, did he take some marijuana off the individual? He said he did. I said, you bring it with you? He'd brought it with him. I said, could you show it to the judge? Yes. I said, you look at it? He said, yes, I saw it. So does that appear to be the same marijuana that you took off the person? It does. I said, I'd offer and admit it into evidence. Now, every person who's a lawyer that's listening to this is saying, that's not coming in. Me, not having taken evidence class, 3 months in on the job, I didn't read any marijuana convictions on appeal. Amazingly, those don't get appealed because they're misdemeanors. The best you get is a fine. The judge denied it. And after about the 6th time I kept asking this officer, does it look to be the same? The nice defense attorney in Morehouse Parish, whose name might rhyme with Scott McElroy, who so politely dug me in the back and showed me there was a number on the evidence thing, and if the number on the evidence bag corresponded with the number on the evidence log, and then on the analysis sheet, you could get it all in. We walked back out front. I got it all in, and the judge, rightfully so, said, great, you've proved there's marijuana and you proved there's somebody standing next to it, but you forgot to prove that he ever possessed it. And at which point, he rightfully dismissed the case. And it was probably the best lesson I learned. I went out after that day and I researched every evidence foundation I could find. I had them wrote down. I pulled them out of appellate records. And still to this day, if I go to trial, I have every foundation, the questions needed to establish that wrote down, the law behind it. So that was my greatest failure. And that great defense attorney took liberty as he ate with my boss every Sunday to remind him for the next 6 years that I didn't get a bag of marijuana into evidence. But it was my best failure.
And so now that we've reflected on that failure, what do you think was your greatest success in getting to try cases in Morehouse Parish?
I think my greatest success in getting to try cases in Morehouse Parish was just simply hanging out in the courtroom day in, day out. I got to see every kind of case that came through. I got to watch some great lawyers. I watched more trials. We were averaging one a month at one point, one jury trial a month. And just to see how these seasoned lawyers came in there, tried their cases, made persuasive arguments. In Louisiana, you can talk to the jurors after the jury trial. We would talk to them. And to hear their logic through probably 40, 50, 60 cases is what built the foundation for the wealth of knowledge I use now to, when I'm picking a jury, reasons why I ask questions in voir dire, the questions you ask jurors. So the biggest success was just simply being there. But compounding that was that I could fail generally without impunity. And I learned that even during the times there was penalty for failure, doing it again and winning far outweighed the failure.
And for the seasoned trial lawyer or the young would-be trial lawyer that's listening, and you just talked about getting to talk to these 50 or 60 juries and their logic, what are some of the big takeaways from seeing, kind of having the veil pulled back at the jury, in the jury room?
I think young lawyers really feel like jurors are persuaded by what we would call sexy facts. Things that are very sexy but often not applicable to the elements. They don't apply to the element. They think that jurors are persuaded by these large statements about things, this argument. And oftentimes, I found with jurors, they all try and stick to the law. Yes, there's always these facts out there that are what we would call these sexy facts, these facts that are very persuasive. But for the most part, jurors do their part to really dive through and figure out what the truth is. I also think that young lawyers, as opposed to older lawyers, do not understand the dynamics of a jury, how much they actually observe the courtroom. They take their job very seriously. So they will watch your mannerisms. I oftentimes heard from jurors, why did this lawyer look at his watch all the time? Why did this person look at their phone? So it was always critical when I was trying a case. I would remove most stuff from my desk. And I even kept a notepad. Secret is, I never wrote anything on the notepad that was of substance. I often would draw arrows on it. But I knew that they were looking at that to see if you were paying attention. And it always was interesting to me how much they paid attention to the aspects of trial. One thing people often forget about is that in a trial there'll be breaks, but oftentimes nobody ever explains to the jurors why there's a break. And so they're just lost. So a lot of young lawyers will just let those breaks happen. A seasoned lawyer will tell the jurors, all right, we just took a break. Now that we're back, I'm going to continue to ask questions you, Mr. Ted. We took a break to discuss issues of law and orient their jurors on what's going on, which then entwines you to the jury. They begin to trust you. They begin to understand that you're out there you're being fully honest with them. People think they can get up there and be dishonest to jurors and not see it, that that's a cunning lawyer. They can smell it from a mile away and they instantly turns them off. All you have is the facts and your take on the facts. Tackle them head on with the jury.
And it sounds to me almost, I think that everybody, myself included even, we like to think of the jury trial as the ultimate theater, the ultimate stage play. But at the same time, the part that you're playing is the part of yourself. And if you are not genuine to who you are, or if you are not playing your part and trying to play someone else's part, they're going to see through it.
They'll see it a mile away. It's very easy to convince yourself that you're something that you're not, but they see through it. You have to be genuine. And the race to genuineness is what wins a trial. That's who they trust. They're trusting the lawyers and the judge to create this atmosphere of genuine truth.
And so you spent those 6 years learning from jurors, learning from defense lawyers, learning from other prosecutors. One of the best trial lawyers that we know in our area, Jerry Jones, and numerous other defense lawyers that are worth mentioning. But you transitioned out of that into being a business owner in the bankruptcy firm. So what was that transition like from being, in a government job to going into a business that was at the time family owned and family run, and maybe lacked some systems and things like that? What was it like, again, going from being where you were responsible for prosecuting cases and not much else to the next week you are now responsible for making sure payroll is made and that prospective clients are seen? What were the biggest challenges going from prosecution to business owner?
The biggest problem is realizing that you sign your own check now. That's the biggest issue, that you're no longer, and how to deal with the stress of that. The transition legal-wise, I started out in criminal law with one criminal law class. I've told many people, when you hire me, I may not know anything about that, but you're hiring my research, my ability to get up on the law and to be able to try it. Becoming a business owner was a wild adventure that I thought it was going to be more pedestrian than what it was. And I went over to the bankruptcy business, and it was great. I had known Orum for a couple of years, Orum being Orum Young's son. I'd known Orum Young Jr., who's the older man, for a long time. We were close friends. it was natural to transition out to DA's office. I was growing out of that. I was actually actively chasing becoming my own attorney. And that was a natural fit. And it's been a natural fit since day one. Transitioning into bankruptcy was difficult. But after about a year of learning the law and seeing how it works, that's comfortable. The hardest transition was as we came at that time when I went to the bankruptcy firm, Orum Young was starting to transition out. And his son, who is Orum Young III, was taking over. And so what I saw was an opportunity. At that time, I was 32 years old. 32 years old. Orum was probably 38, 39. Joe was 35. I saw...
And this was, and Orum, for the listener, he was recently out of law school and had just passed the bar at that, and his dad was in the process of handing off this massive business that is, that even then, I mean, I didn't grow up seeing these commercials, but you grew up even seeing these commercials in between Saturday morning cartoons or during the evening news.
And I think that's the funny part. I should drag Orum here on this. Orum walked in, passed the bar exam, and his dad said, "I want to retire." And literally just didn't show up. And now he's inherited what is 5,000 existing bankruptcy clients. At that time, we were filing roughly 1,000 cases a year in Chapter 13 in bankruptcy court. And he handed it off to him. And, it's astounding that we stumbled our way across it. And we inherited a firm. We had 75 Hahn filing cabinets. I beg you, if anybody needs a Hahn filing cabinet, I will pimp your ride. We still have them to this day. You're welcome to come get them. You just find me, shoot me a message, and we'll get it done. I've offered them to anybody. I've even offered them for free, and nobody will take them. But we converted it to an electronic practice.
And I remember when that was going on, because you basically had a handful of guys in a back room who their only job was to scan, every day was just to scan stuff in from these filing cabinets into the system.
Oh, it was wild. We would pay college kids to come in, scan the files, take out the wet ink signatures and save them, and then box them up. I think we went through somewheres north of over 2,000 bankers boxes. And at that time we were rolling, but the shred company had offered to do it in one go for $70,000. So Joe, who's much more enterprising as a law partner, found out that you could sign a $75 a week contract and get as many cans as you wanted. So he just requested 8 cans. We'd fill them up. They'd take them off. It was this wild ride. But we were 3 young guys trying to figure it out. And essentially from 15 through 20, we turned it to a completely electronic practice, of which now we have a call center in Mexico. We have employees answering in Guadalajara, in Puerto Vallarta. We're triaging somewhere between 400 to 600 calls a day. We're doing leads in excess of 3,000 leads a year. And, as COVID starts to come back, we're headed towards 1,100 bankruptcies per year. And now we're statewide with one office. So it's from 16 through 2022, it's been a steep climb. But the ability to make that climb and to cascade up in this world was from the time I was in Morehouse Parish, where I had creative freedom to fail. And I learned there that failure is not as bad as you think it is. It's the building block of success. And that was a lesson I learned early on. This just continued. I became less risk averse through those years in Morehouse Parish, and that's created over into the bankruptcy business.
So do you think that your time spent learning trial skills or learning people skills, jury skills, is what helps you in the bankruptcy practice today?
I think those are the skills that help me manage my kids.
Okay, that's fair.
I think what I learned through both those, the thing that cuts across is how to deal with people. Client control is the ultimate in being able to control your practice, is being able to have control with your client. Your client demands that control exists. They came to you as a professional to hire you for your professional advice. And when you don't have client control, you don't have that. The same exists with the jury. When you can't have control of the facts at a jury trial, you won't win. It's the same thing. It cuts across. So the experience I had is that I was very resilient to failure and willing to risk more than most.
And what do you think is one of the biggest successes that you have enjoyed since being, one of these business owners or one of the owners of Orum Young now?
I think the greatest success that I've had in that degree is that Orum came to me in 2016. He said, I want to turn this thing completely electronic. At that time, we had a 6-line phone. So what you would do is you'd watch the 6 lines on the phone light up. And when I didn't have a client, I'd pick it up and I'd say, Orum Young, how can I help you? They say, is that you, Mr. Jones? I say, oh, that's me. And so I would triage the phone like that. The first thing was technology. I think that's the biggest battle we reined in our phones. We became voice over IP phones, at which we then gained control of. We could track who was actually calling in rather than just somebody picking up the phone when you didn't have something to do. And then from there, we grew from 6 employees on up to upwards of 30 employees. I think Orum coming to me and saying, we have to do this in a better way. And that he wanted to put technology in it. I remember actually me and him got into it very quaintly up by a water fountain one day. Joe was trying to mediate.
And just so we're clear, is this young Orum or the older Orum?
This is young Orum.
Okay.
And so we're debating how much technology we should get. I'm saying let's replicate. He says we need to go ahead and move on to better technology electronically. We're going to scan everything. And in January of 2017, I went and saw what this technology could look like with a group. And at that day, I said, let's do it. Mm-hmm. And we spent the next 4 years building it out. And thankfully, each one of us is versed in something different. One's very versed in software systems, understanding things, putting these systems together. Joe's very versed in court. And I do most of the client front-facing stuff, so I was versed in the intake and other things. And we just built that into a system. But that by far has probably been the biggest success, is to watch that office grow from 75 Han filing cabinets to 20 scanners and no paper files except for wedding signatures that were required to keep by the United States trustee in the bankruptcy court. To watch it grow from 6 employees to 30 employees across 2 countries, that's been the greatest success. And just knowing that there were a lot of failures. Keith, you can tell them all along the way. I've called some very, very bad nights and said, hey, can I borrow your credit card? This might have gone south. But thankfully, with big risk comes big gain. And I'm very fortunate and lucky that I had the ability to take that big risk.
What do you enjoy more? Did you enjoy being the trial lawyer more, or do you enjoy being the business owner more?
I enjoy success. So did I enjoy? Yeah, they're 2 different beasts. I enjoyed being a trial lawyer, but I enjoyed the success of being a trial lawyer. I didn't enjoy the failures, although I learned more from them than I did the successes. I think overall I just enjoy success. It's probably part of why I created Erase My Arrest initially. And me and you had discussed doing something like that for a while. Mm-hmm. And on why my then wife was having our 3rd child, I created the website while sitting in the hospital room that night. It was just, at that point, I'm more addicted to the success and watching things be successful. And that's the joy I get from both of those, is being able to do them and be successful.
So what is next for you professionally and even personally? Or maybe they bleed into each other in this way. What is next for Devin Jones? What is next for Devin Jones as a business owner of Orum Young? What is next for Devin Jones as a business owner in Erase My Arrest?
I think the next move that I'm going to make personally, just look for me to continue to try and replicate the success that's existed. I know that we need to pump more into the bankruptcy. Our motto over there, our actual company core value is that we want to help 1,200 families get debt relief a year becoming the largest consumer bankruptcy firm in Louisiana. But I think the reality is we really want to build towards that. The same it is with erase my arrest and the expungements. The goal there is to help more individuals facilitate cleaning their records and becoming the premier expungement firm. And erase my arrest is slowly becoming a lead source in states that we don't practice law at. And I think in bankruptcy, we're going to continue down that path as the times are getting harder for people with this debt. I think we're going to become more of a lead source as people call us from Arkansas, Texas, Mississippi. So at some point, what we're doing lead source wise in erase my arrest is going to start bleeding over to the bankruptcy business. Although we can't sell our product in that state, we can get them to somebody who can sell them a product. So I think the evolution of law firms is that most of this is occurring through internet interface, through social media. And I think the next move for us is in states we can't offer the product, we can offer to connect them to somebody who can sell them that product.
And so for the young business owner or the young lawyer, or maybe you are the young firm owner who has in fact hung out his or her own shingle, and you are hearing these stories of success and growth in only, 5, 6, 7 years. What advice do you have for him or her?
Pursue success with reckless abandon. I can remember there was days, I remember being in the prosecutor's office and I got a $400 tax bill one Christmas. And I thought, how would I ever pay that? It's some of that sentiment that I've thought about, that I never want to be in that position. So I've, with reckless abandon, pursued success. Now, you have rules, you have other things you have to stay within. As long as you're within the confines of your rules and acting, gamble that dollar. So many people get success and they want to spend it on things that show they have success, that are unsustainable. Reinvest that dollar in your business and watch it grow from 1 to 10. Pursue the avenues that you need. Just go after it. You have to. All starts with passion. You either have it or you don't. If you don't have passion in your profession or what you're doing, then you're never going to be able to have reckless abandon chasing success. Passionate people will use reckless abandonment to chase success, and you have to chase success, and you can't be scared of the failure. Failure is a speed bump, not a death.
And Devin, this is going to be the last question, and it gets back to the name of our podcast, Citizen Effect, leaving something better than how you found it. We've talked about how you came into the space that you're in today. We've talked about how you have transitioned from a trial lawyer to a business owner. How do you plan to leave this space better? What is going to be your legacy, your impact on this space?
I think it boils down to technology. I think when you look at it, I hope to leave this space better by the use of technology to better offer services to our clients so that more people understand what lawyers do and what we can do. I find in most businesses, other lawyers worry about lawyers stealing their clients. The reality is almost all the market research says that lawyers don't steal other lawyers' clients. They just don't create clients. I think we're in the business of creating clients. And we create clients by allowing people to know that we have a product or a legal solution that can help them. I think the mark I want to leave is that there's the technology and systems that we've done to create this statewide bankruptcy firm and this almost nationwide expungement firm through the use of technology to avail more people of the options that they have legally to help themselves. And that's how I want to leave this space, is that I was able to get in front of people more products than anybody else was to help them that they didn't realize existed.
And with that, I don't think there's a better way that we could end this podcast. So this has been episode 1A of the Citizen Effect podcast. Thank you, Devin, for finally pushing me to get this done. Thank you for being officially the first guest, even though you are a co-host of the same. And again, I'm Keith Whiddon, Whiddon Criminal Defense, and one half Erase My Arrest, Devin, Erase My Arrest at erasemyarrest.com. We'll see you on the next episode.
See y'all later.